One of the craziest legal stories you'll ever hear. Introducing George Pickering, whose son was on life support at a hospital after having a stroke.
His son was scheduled to be taken off of life support, and an organ donor organization had already been notified. But George said that he knew his son wasn't brain dead because he had felt him squeeze his hand.
When hospital staff and his own family members refused to listen to him, he got desperate. George pulled out a firearm and began threatening everyone in the hospital, which led to a several-hour-long standoff with the SWAT team.
And according to George, these additional hours were all that he needed, because within that time, his son started squeezing his hand on command.
With confirmation that his son was not brain dead, George surrendered, and his son eventually fully recovered. Now, to be clear, there's more to this story than what's usually reported. George admits that he was belligerently drunk during this whole ordeal.
And it appears that the boy's mom had actually consented to him being taken off of life support. And due to privacy laws, the hospital hasn't been able to tell their side of the story.
But as for the law, George was initially charged with 2 counts of assault with a deadly weapon. In Texas, where this happened, each count carried up to 20 years in prison.
But one count was dropped and the other was reduced, meaning that George actually spent less than a year in jail, even though he, technically speaking, held a hospital hostage with a gun.
This case is a good example of the huge discretion that prosecutors and judges have in the criminal system. Even when a law is broken, punishment can almost always be shaped how they see fit.
Well, here's one time it seems like the legal system got it pretty much right. The father did not hurt anybody and he saved his son's life in the meantime. But the thing to note here is how much discretion a court has. When it's working in your favor, it's a great thing, but when it's working against you, it's a very scary thing and can be a very terrible thing as well. This could be a case where the defendant gets sued. He did point a gun at people, and that is assault, even if he didn't shoot someone. If he shot someone, that would be battery. But simply the threat of harming someone is an assault, and he could have ended up getting sued for defending his own son's life. And if the jury did not like him, even if it was not for the assault, if for whatever reason they could paint the defendant in an unfavorable light, he could have gotten hit with a very serious and hefty judgment as well. So the discretion of the court is something to watch out for. You don't want to be in a position where you risk an unfavorable outcome by a jury who could just go off the deep end. This is why it's always better to settle a case. And if you're going to settle a case, it is great to have an offshore trust to help you negotiate.